Hi, everyone. I am here today to bring you a breakdown of a notice that I've just completed, and it's for Washington State. Pretty heavy bill they just put out, and we going to start doing the videos with our notices to help others understand, why we do them, how important they are, because they allow us by right to instruct our representatives. Well, they don't allow us to, they give us a tool to, our inherent rights allow us to instruct our representatives and officers of government. So I'm going to share the screen with you, and we're going to go through the notice and break some things down and hopefully give a better understanding. Okay. So again, this is going to Washington State. So we're going to send it to the governor, to the Washington House, all members, Washington Senate, again, all members, the committees involved, Human Services, Youth and Early Learning Committee, all members, and then the Senate Human Services Committee, also all members. And then this would be for whoever would like to send a paper copy in, certified or in person, either way. But it's super important to make sure the legislature is always notified and put on alert with this lawful notices and affidavits, because we haven't been taught the laws properly, and they are really, trampling on the people. So this notice, unfortunately, was necessary, but I'm going to get started. It's a notice of maladministration for Senate Bill 5599 and interference of inherent rights of parents. And then we have the notice to principal is notice to agent, and notice to agent is notice to principal. So whoever the principal person is, like the Speaker of the House, the President pro temp, and then the committee chairs, they are all like considered the principal, and they must distribute down to all the agents below them. Okay, so we start out with I, one of the people. You're coming in your full capacity as one of the people of the 50 Republican states. And we put that wording in there because then everybody can sign, with us, because we're one of the people in any of the Republican states, no matter where we go. So that doesn't change from state to state. But we put in parentheses as seen in Washington State Constitution, Article 1, Section 1. And we come sui juris, which means you're coming of your own right. You're not being under any guardianship or any legal, coercion. You're coming of your own sound mind, and bringing you express notice so that you and your agents may take immediate due care. Please take notice that all political powers are inherent in the people, and all government has been instituted solely for the safety, happiness, and protection of the individual rights of the people. And then we'll have the evidence below. Washington State Constitution, Declaration of Rights, Article 1, Section 1, political power. All political power is inherent in the people, and government derive their just powers from the consent of the governed and are established to protect and maintain individual rights. Washington State Constitution, Article 1, text of Section 4, right of petition and assemblage. The right of petition and of the people peaceably to assemble for the common good shall never be abridged, which abridged means it will never be taken away, can never be taken away. And then we have a please take notice Senate Bill 5599 is repugnant to the Washington State Constitution, and as public servants and trustees of the people, Your utmost duties are to write laws that are in pursuance of the Washington state and US constitutions. And this part's really, really important because a lot of the statutory laws that are being created right now are not in pursuance of our state constitutions. And that's a huge problem because there's a framework that, of the each state constitution. And when they start to go outside of that with creating legislation, then we have problems because, that's how they run the people over, unfortunately. So if it comes against us in any way, shape, or form, it basically is null and void on its face because any laws must be in pursuance. And this one is definitely not. So we're going to continue on. So we asked them questions too within here, to ask them to show where you were given clear grants of constitutional authority to delegate any powers to any agencies, associations, groups, and foster homes or nonprofit organizations to not notify parents of the minors' whereabouts immediately and are given broad discretion within SB 5599 to wait 24 to 72 hours or to not notify parents at all. This bill also delegates unlawful authority to Child Protective Services of Washington State. So guys, this is statewide. We really need to please support this notice because Washington needs help. To take children from their parents at any time if they do not agree or want their child to receive unwanted medical advice and offered various forms of treatment that can permanently alter their minor children without the parents' knowledge or consent. Washington State Constitution, Article 1, Section 3, personal rights. No person shall be deprived of life, liberty, or property without due process of law. So going back just a little bit, CPS has destroyed a lot of families. We know that it's a subject that, a lot of people don't like to look at. It's very ugly. It's very, it's a lot of things. But to stay on point, our general assemblies have been giving out so much authority to these agencies, within our states and the federal Congress as well. And it's way, way outside of the framework of the Constitution. So that's how we're able to give them a frequent recurrence of the fundamental principles frequently, and they are to be accountable to us. This is how we, the people, collectively keep government good. It's up to us. It's not up to them. They're not our leaders. We are, to be good stewards and, to stay checked in. We can't stay asleep at the wheel like we've been, and we weren't taught. A lot of things were hidden from us, a lot. So, it's not all our fault, but now that we know better, we have to do the right thing for the kids in the country. So that's how this came about. And then the next provision is Washington State Constitution, Article 1, Section 3, personal rights. And I did read this one, but that's okay. No person shall be deprived of life, liberty, or property without due process of law. So CPS is not coming in and taking children, depriving life, liberty, or property. Washington State Constitution, Article 1, Section 12, special privileges and immunities prohibited. No law shall be passed granting to any citizen, class of citizens, or corporation other than municipal privileges or immunities which upon the same terms shall not equally belong to all citizens or corporations. So they cannot pass any laws that, a certain class of people get these special privileges and they can't do that. So we're all created equally. So this needs to be equally lawfully created and within the constitutional framework. Then we're going to go down to Marbury versus Madison. of 1803. Thus, the particular phraseology of the Constitution of the United States confirms and strengthens the principle supposed to be essential to all written constitutions, that a law repugnant to the Constitution is void, and that courts as well as other departments are bound by that instrument. So they're bound by the Constitution, especially when they swear an oath. So they're bound by it, and they must absolutely stay, they're bound. And Miranda versus Arizona of 1966, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Again, take away our rights that are secured in each state constitution. They can't do it. So, okay, fundamental principle, maximum of law, 49L. That which is against divine law is repugnant to society and void. And that is a common law maxim. And then we go to a section of the Social Security Act of 1935, and this goes back to the original legislative intent of this act created, which is very important because a lot of times the original intent gets lost after it's been abrogated, changed, altered, added to, they have changed so much on us. But this section is good protection. Please pay attention. Social Security Act 1935, 1101, Section 6D. Nothing in this act shall be construed as authorizing any federal official, agent, or representative in carrying out any of the provisions of this act to take charge of any child over the objection of either of the parents of such child or of the person standing in local parentis to such child. So either parent objects, they are not allowed to take children unless there's imminent danger that they can prove, with affidavits. And, even that's kind of questionable sometimes. They don't really operate with integrity. And local parentis means like a guardian, whoever is standing in, guardianship for that child. So that's really, really important to know. And the legislator needs to know all of this as well. And that's why we're going down, showing them that, listen, you can't just come in and take children away from parents because they don't agree with their child's transition choices and such. And they can take in, if the child runs away from home, they can, go to all these places that they have, nonprofits and such, and, they don't have to notify the parents, and it's just egregious. So, anyway, Washington State Constitution, Article 1, Section 30, rights reserved. The enumeration in this Constitution of certain rights shall not be construed to deny others retained by the people. So they can't construe any other rights retained by any people to make them fit and take away from other people's rights. Kind of a lot of what we're seeing right now, actually. So, and then Washington State has a mandatory provision, which is fantastic. So it's Article 1, Section 29. The provisions of this Constitution are mandatory unless by express words they are declared to be otherwise. So they must, and every Constitution is mandatory, but only a few have the wording, but we can use it in any state. So then we go down to another, please take notice that as elected trustees and servants of the people, you are strictly bound by sworn oaths to the trust indenture, the Washington State Constitution. All provisions of the Washington State Constitution are mandatory, and you may never abrogate inherent rights of the people as you swore to protect and maintain individual rights. Parents have a historical, fundamental right to be in the care, custody, and control of their children and their education. We're going to see evidence below, and we're going to read the Troxel or versus Granville case from 2000. The 14th Amendment provides that no state shall deprive any person of life, liberty, or property without due process of law. We have long recognized that the amendment's due process clause, like its Fifth Amendment counterpart, guarantees more than fair process. Washington versus Glucksberg, 1997. I really want to highlight this part that's highlighted. The clause also includes a substantive component that provides heightened protection against government interference with certain fundamental rights and liberty interests. Our children are our liberty interests. Our interest is, we have their liberty and their freedom is our interest as, the parents and such. And there's also another Reno versus Flores case from 1993. Again, the liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children is perhaps the oldest of the fundamental liberty interests recognized by this court. More than 75 years ago in Meyer versus Nebraska, 1923, we held that the liberty protected by the Due Process Clause includes the right of parents to establish a home and bring up children and to control the education of their own. 2 years later, in Pierce versus Society of Sisters, 1925, we again held that the liberty of parents and guardians includes the right to direct the upbringing and education of children under their control. We explained in Pierce that the child is not the mere creature of the state. So when they go to school, that does not mean they have care, custody, and control of them. Okay, it's telling you right here. It's our fundamental liberty interest to be in the care, custody, and control of our children and their education. So this has been very well established, as you can see. Okay, so those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations. We return to the subject in Prince versus Massachusetts, 1944, and again confirm that there is a constitutional dimension to the right of parents to direct the upbringing of their children. It is cardinal with us that the custody, care, and nurture of the child reside first in the parents, whose primary function and freedom include preparation for obligations the state can neither supply nor hinder. So they cannot interfere and hinder things, and this is huge. So we definitely wanted to use that in here. And then the maximum law, 62I, a thing void ab initio, which means from the beginning, is one that never went into effect, and that's a common law maxim. So because this bill is so outside the framework of the Constitution and it tramples all over fundamental rights of parents and our liberty interests, our children, it was void before it even got off the ground. And so it's not lawful. So it never went into effect technically. So we're going to do our final paragraph here. Please take final notice. It is my wish, order, and demand that all legislative members immediately cease and desist in attacking the inherent natural rights of the people. As public officers, you have sworn an oath by contract to always protect and enhance our rights only. Please show the constitutional provisions that allow you to usurp your limited authority and trample on or infringe against guaranteed rights of the people. Please respond by affidavit, point by point, sworn under the penalty of perjury within 3 days, 72 hours of receiving this notice, or you agree by acquiescence all statements in this notice to be truth and law. Further, you agree that you are acting with full knowledge, intent, and malice by trespassing against the inherent rights of the people, and each encroachment after notice given will bring a financial penalty of $500,000 per infringement, and that no court shall be able to rehear this matter, but it shall stand as evidence, truth, and law in all courts of record. This notice is sent to you in peace with the love of Christ, so that you may provide due care to those who have all the political power, the people. So this is going to be put into a job form, and I hope you all will sign it in support of Washington and all of the families out there, because unfortunately, CPS has ripped apart a lot of families, and we don't need any more being torn apart by their unlawful agendas. So thank you, everyone, and I'm going to end the video here.